Okay, good morning everybody. It's just gone 9:30, so time to resume the hearings as part of the examination of the Dacorum local plan. First of all, can everybody hear me okay at the back? Yeah. Welcome back for those of you who attended on previous days, and welcome along for those of you who haven't yet appeared before the examination. My name is Matthew Birkinshaw, and alongside me is my colleague, Mr. Thomas Bristow. We're both appointed by Secretary of State to examine the local plan. Before we get going today, there's a few housekeeping matters to go through. As ever, Louise St. John Howe, the Programme Officer, is in the room and will be about today. So if you have any questions, queries about documents, the library, the sessions, or attending any of the sessions either today or for the rest of the examination, please do speak to Louise. Before we get going there, if I could just ask the Council again just to run through any fire and emergency procedures that people need to be aware of whilst in the chamber.
Thank you, sirs. Good morning. So just to confirm with regards to the fire test, we're not expecting a fire alarm test today. The fire alarm test takes place on Tuesday mornings at 9:30. The fire evacuation alarm in the forum is a voice alarm system rather than a traditional siren. The alarm will announce that the building must be evacuated due to an emergency. On hearing the fire alarm, everybody must immediately leave the building by the nearest available route, which for anyone in the council chamber in the room next door is outside of the council chamber down the stairwell immediately in front of us. There is a second stairwell just past the lifts to our left. Please follow a fire marshal, and if in the event of a fire you would need assistance in using the stairs, please make reception aware now. The main assembly point is at the Market Square, which for those who do not know the location of that, if you do follow the route and make your way out of the building, you cross the pedestrian crossing next to the council offices and you walk down the high street for a short distance and Market Square is there on your right. Toilets are located to the left of the council chambers after lifts, and there are also further toilets downstairs by the cafe. The hearing sessions today are being live streamed and recorded to be made available after the session. Please be aware and leave the council chamber if you do not wish to be filmed. That's everything, sirs. Thank you.
Okay, thank you very much. Just a couple of points from ourselves before we go around the room and ask everybody to introduce themselves. As we've done on previous days, for those of you, slightly unique request, but please can you not use any mobile hotspots? It interferes with the microphones, and the microphones are linked then to the online stream as well. If people do need to get online, there are Wi-Fi networks available. There's a guest one. There's also one with the password is on the desk for anybody. Again, if you have any questions or queries regarding that, please try and grab Louise at some point during the day. But it's worked, I think, pretty well for everybody so far whilst we've been here. But just a reminder. Yeah, phones on aeroplane mode or anything that won't interfere with the microphones. We're moving on the examination. Obviously, today we're focusing on Tring and the allocations at Tring. We have spent a lot of time already in this examination talking about site selection methodology, spatial strategy, the council sort of reasoning for their justification for allocations. So what we will do as per other sessions is we will go through the matters, issues and questions, but Mr. Bristow and I will not ask every single question. We may group questions together. The purpose of the hearings today is obviously to allow us to get the necessary information that we need to form our own judgments, but also an opportunity for you to put your points forwards. So please do engage in the debate, please do take part, but please do stick to the points that you've made in your representations. The hearings are not an opportunity to add any new points or build upon others that you haven't made. So engage, please, participate, please, but stick to the points you've made. The second sort of health warning from me as well is we are acutely aware, obviously, of the planning history, especially as regards one of the sites that we're going to be discussing today, TR03. The local plan process is different. It's not a public inquiry. We're not here to hear detailed presentation of evidence. We're not here to cross-examine witnesses. and Mr. Bristow and I were pretty clear and pretty firm on that. We've got the evidence. We can take that as read. Really, the purpose of the hearings are for us to explore the issues in further, and it's also slightly different in the context of a local plan, because we've been talking about this issue sort of on and off for weeks, really, in terms of all the different strands that go into the council's sort of ultimate sort of thinking behind their local plan. So a lot of the debate we've had it around site selection methodology, we've had it around spatial strategy. So again, those topics will no doubt crop up today. But if Mr. Bristow and I sort of move the debate or discussion on, it's probably because we've already heard what people have got to say. So we really do want to focus today's session on some of the really sort of the key issues, really. With that in mind, we'll go around the table. As we do, if you let me know, I'll see who you are, if you act on behalf of a particular client or group, etc. And if you could just let us know which of the sites for today you're here to discuss. If, as I'll give a spoiler alert, we are going to take TR03 first. So if you're not here to discuss land east of Tring and you want to get a coffee downstairs, we won't be offended. So just put that out there now. We'll deal with that site first. But again, if you could just let me know as we go around the table, again, any particular client or group, but also specifically which site or sites you're here to talk about. Thank you.
Good morning, sirs. Good morning, everyone. My name is Ronan Layden. I'm Head of Strategic Planning here at Dacorum Borough Council. I'm accompanied today on my right by Craig Howell-Williams, King's Council, representing Dacorum, and on my left is Ms. Keely Mitchell, Principal Planning Officer for the Council also.
Good morning all. I'm Mark Murphy. I'm from Pegasus Group and I'm representing Catesby Estates in relation to TR002. Thank you.
Good morning all. I'm Hardy Wright, planning consultant from Vincent in Golding, representing Hart CC and in particular TR01.
Good morning. I'm David Forster, King's Council, with Pippa Cheatham to my right, representing Grove Fields Residents Association. We're here for all three sites, east of Tring, New Mill and Dunsley today.
Good morning. I'm Nicola Brown, Chartered Landscape Architect with Huskers and Brown Associates, and I'm here representing Tring Town Council, predominantly in respect of TR03.
Good morning, my name is Trevor Standen and I am the planning advisor to Tring Town Council. I'm here today in respect of TR03. Thank you.
Hello, my name's Chris Wallace. I'm from Tring Sports Forum and I'm here to look at the site allocations for Tring.
Mike Billingham, also from Tring Sports Forum. Is that me?
Well, that's better. Good morning. It's Matt Thompson from the Chilterns Conservation Board. We're here primarily to look at TR03, but we're also happy to provide landscape evidence on the other two sites if called upon to do so.
Good morning, Bob May from Ryan and May and my colleague Samantha Ryan from Ryan and May. We're here for TR03 on behalf of Red Row.
Richard Turnbull, planning advisor for the Chiltern Society, primarily for TR03, but also an interest in the other two sites.
I'm Dave Gardner, also the Chiltern Society, here for all three sites and part their planning team.
Okay, thank you very much. what we'll do is we'll work through the matters, issues and questions, some of which we may group together, some of which we may find that we've actually already discussed, and there may be a sort of briefer debate or discussion. The first question is really getting into some of the the crux of the objections, really, and this is a point that's come out, as the council will be more than aware, in a lot of the representations. We just want to really sort of understand at a high level the council's position. And for those of you that are here on Tuesday, this cropped up on Tuesday, so there might be a little bit of repetition, but it's a sort of a good opener, really. So we all know the planning history of the site, and in particular the Secretary of State's decision. And I guess a question from a lot of the representatives and a lot of people around the table has been really knowing what the council knew about the planning history, and in particular the Secretary of State's decision. What's the council's justification, at sort of very high level, what's the council's justification for including this as a site allocation in the local plan?
Thank you, sirs. So I'll probably start by saying what's the justification for the allocation in the plan. And I think the first and foremost point to make on this, it is ultimately plan-led and led by the evidence that informs the plan. So, and set out within, summarized concisely within ED 39, which we've referred to quite a bit since the start of this stage 3 hearings, and briefly discussed at the start of this week. I went through line by line with this site, how that applied, and how we've considered a range of evidence and a range of considerations that are the benefits of the scheme, but also considering that against any harms. And by that, we've considered the impacts on landscape, the impacts on the green belt, in terms of green infrastructure, biodiversity, flooding, environmental considerations, historic environment, highways impacts, and the potential to deliver sustainable transport. And in addition to that, we've also considered the impacts on the infrastructure in the area as part of the IDP work. We've had feedback from our environmental health team within the council about any considerations that we may need to take into account also, as well as that of the Minerals and Waste Authority. And we've also subjected all to viability evidence. And that's all just summarized within ED 39, and various references are set out within that. The site's also been subject to the SA, and we've discussed at length already the nature and purpose of the SA and its need to consider, a range of options. And for the council, in light of those options, variations to a strategy to choose its preferred approach. And then within ED 39 at the end, importantly, we've set out our conclusions and recommendations for why we feel certain sites should be allocated. And we include within that recommendations from 2020, when we first recommend this site to be allocated, subject to public consultation then. We gathered a lot of feedback and understanding of key issues from residents, local communities, and other stakeholders. And then we moved on and we spelled out the reason, justification for why the site was suggested to be deleted as an allocation as part of a focused consultation, the revised strategy for growth, and we sought views on that also. And that finally, we, most recently for the Regulation 19, we sought to propose the allocation again for the same quantum of growth as we did in 2020. Now that we know a bit more understanding in light of beachwoods, special areas conservation, our habitats regulations assessment, and the need to secure mitigation, with better understanding of wider matters with regards to national policy, being more clear on the number of homes we should be delivering in the local plan. And we have also, had regard to the prevailing nature of the new planning system also. So it has been ultimately plan-led, and the evidence informing the justification of this allocation, has been plan-led. Now, beyond that, we then need to take into, in our view, any other considerations that may come our way. And as part of that, and since, much of that evidence on landscape and greenbelt has been done, we've been through an extensive process. I was part of an inquiry for land use of Tring, and as expert witness for the council dealing with the local plan, dealing with 5-year supply. That was part of the process where we had to determine and conclude that our supply was, acutely short. And as part of that, and taking that into account, but there's been wider matters discussed as part of that inquiry. And ultimately, following that, we received the Secretary of State decision on this side. I do note also on that when it came to the council's decision on this, in the first instance for refusal, the main reason for refusal, and I think the only reason for refusal, was very special circumstances case and the balance of that. Now, I think just being very, very clear on that is, while the Secretary of State determined that very special circumstances did not exist at the time, officers, through our own separate evidence and tests here today, consider that exceptional circumstances exist to remove this site from the Greenbelt. Recognising the very special circumstances case is importantly and considered by all in the profession to be a more stringent test to the exceptional circumstances test. And the Council's response to matter 5, question 1, confirms that the appeal decision turned on a planning judgment in relation to national policy and the test of very special circumstances. And the Council has reached a different conclusion, having regard to all relevant considerations in the different policy context of the local plan. So I think that is a helpful starting point for that, and we just want to be very clear on that, if that's okay, sirs. Thank you.
And also, Director, for those that are here on Tuesday, I directed a lot of questions at the council around site selection methodology and Tring in particular. The question really for Grove Field Residents Associations, this is a point that comes out in your representations. The Secretary of State's decision was, it wasn't referring to the preparation of a local plan. And in that decision, the Secretary of State reached a different view to the appointed inspector, and there was a planning judgment to be made, and the Secretary of State reached a conclusion that very special circumstances didn't exist to grant planning permission. Just in terms of the Secretary of State's decision, and we won't get too much dragged into sort of landscape and other sort of effects, just in terms of the actual principle of decision, why does that mean that we couldn't find this allocation sound?
I'm not saying that. I'm saying that the elements that went into that decision, such as greenbelt harm and national landscape area and the best and most versatile agricultural land, are all elements that have been found following a fact-finding, the full inquiry process, have been found by the Secretary of State at the top of the planning tree. And our basic point is that the council has to have very good reason for departing from those and not taking those into account in the allocation decision. And if I can just take you through a few examples to show the point. I mean, as a matter of basic principle, when the Secretary of State makes a decision on the site and makes decisions as to the extent of greenbelt harm or the impact on the national landscape area, just as a matter of principle, that's a highly influential material consideration for the planning of the area generally for the future. I mean, it's just a decision at the top of the planning tree, and the case law shows that lower tier decision makers should highly respect, I'm not saying being bound by, but highly respect those findings on the specific issues, unless there's material change in circumstances. And that's the power gen case and the Evans case. So just a basic principle that you don't go back over and you don't second guess higher tier decision makers. It's just a matter of constitutional principle. Now, the matrix here, of course, is different. I totally accept that in exceptional circumstances is different from very special circumstances, and plan making is very different from Section 78 appeal. I totally get all that. But let's look at what actually happened with the decisions of the Secretary of State and how they followed through into this allocation decision. And that's where we say it's all gone wrong. So, for example, can we just pick up the Secretary of State's decision letter, please? I can do this in the shorthand way. I'm not going to go to the inspector's report in detail because you'll get the headlines, I think, from the Secretary of State's decision letter. So, if we can take up, please, SSA 6.1, and if I can start with greenbelt. At paragraph 24, which is just in with openness, and you'll immediately see the loss of openness would be significant due to the large scale of development, and the proposal would result in significant harm to its openness. So that's the starting point. Then 25 is looking at the purposes, and you see for the reasons set out by the inspector, so adopting what the inspector says, we've got the inspector and the Secretary of State both concluding that the proposal would result in significant harm to greenbelt purposes A and C, and would have a significant adverse effect on the openness and the purposes of including land within the greenbelt. So a high problem in greenbelt terms found through an adversarial procedure with an inspector who did site visit and all that sort of stuff, endorsed by the Secretary of State. And then we see at 26 substantial weight to all of that. And that's all, I say, a benchmark against which an allocation then falls to be considered in the sustainability appraisal and what follows. If we look, please, at the sustainability appraisal 24, so this is document CD 3.1. We've been through this a lot on Tuesday, but we see that at 5.4.47, which is at page 34, I hope, we see this, there's no stone unturned for Berkhamsted and Tring, not just for Tring, so you've got to have no stone unturned, so that applies equally to any of the higher growth scenarios for Berkhamsted. And secondly, the reference to the Secretary of State's decision letter saying whilst it was dismissed, the reasons for refusal serve to suggest that there remains scope for the site to be allocated through the local plan if necessary, which is, in my respectful submission, a complete inversion of what's been concluded. But then we go to section 6 of this document, and we see that the green belt comparative harm is left out of account. And if we go to table 6.2, which we were told on Tuesday is the basis, this is page 65, I think, table 6.2, that this is the basis for going with option 7, you see that green belt harm isn't considered. Then we go to the proposed allocations, and the only reference we get to greenbelt at all is at 9.17.25 at page 93. I hope I'm not missing out any relevant document, but this is the key logical chain. And all we see here, there are clear greenbelt sensitivities. That's all we get. And then we get to ED 39, which is, I mean, I think all of what I just said was effectively part of the logic for you setting out your ED 36 questions. But if we go to ED 39, we're then looking for how greenbelt is dealt with at page 114 through to 117 for this site. And we see that we get a reference to, at page 114, we get a reference to greenbelt evaluation, and it does correctly refer to strongly in the greenbelt studies. That's correct. But it doesn't refer to the Secretary of State's decision letters, the most up-to-date decision, and the conclusions I just referred to in DL 24 to 28. And we also note that in the right-hand column, it's orange, it's not red. And so basically any site that has a greenbelt problem will be scoring orange, even if it's a much lesser greenbelt problem, which is our point about some of the Berkhamsted sites that we've raised previously. So this is being, despite the Secretary of State's conclusion, and indeed despite the greenbelt studies review, the harm to the greenbelt here is being equated with any harm to the greenbelt of any site anywhere. It's just an orange, so no weighting of that at all. And then if we get to the text later on, we get the text for 2020 and 2023, and then we look at where we find the analysis of the greenbelt harm, or putting that into the scale, or how we see the Secretary of State's decision letter being followed through. And you might have expected in the third paragraph on 117 to have found an exposition as to the significance and weight to be attached to the greenbelt harm. But you don't. You get the opposite. You get the exposition of no technical issue, and then just the balance of harm to the greenbelt versus benefits. So you don't get any exposition or assessment of the greenbelt harm in the overall balance, nor do you get any comparative assessment of the greenbelt harm. I'm going on a bit, but I mean, this has been encapsulating quite a bit of our case.
So this is a case of, and again, this touches upon, I know you weren't here, but I think it probably touches on a lot of earlier sessions that we had around this and the sustainability appraisal, and also the session that we had on Tuesday. So your case, and it's not necessarily. So I think a lot of people have, and I get it, I understand why, have sort of jumped on the Secretary of State's decision and said, that's a decision that must mean this site is sort of forever forgotten and shouldn't be in a local plan. But I think what you're saying is actually it's a bit more nuanced than that, and it's actually some of the issues that have come out around greenbelt harm in particular haven't then been translated into the evidence and tested. And presumably it is a case, would you agree, that a council could allocate a site and remove land from the greenbelt where it was performing strongly, and it did, it did, and I think I touched upon it, I just picked it at random, but we talked a lot about the Hammer Garden Communities project and how the council said, look, we accept performs well in some of the greenbelt purposes, high levels of harm on sort of this side of the balance, but over here there's all these benefits, and actually we think in our judgment that justifies it. So you're not saying that the council can't do that, it's just a case that they haven't then gone through this process, and the SA doesn't really give us the answer, and then nor does ED39.
Right. That's exactly the point. And that's for greenbelt. And the starting point of the Secretary of State's decision is necessarily highly material, and it goes into the pot. And we don't know exactly what the decision of the Secretary of State would have been for East of Berkhamsted, for example, but we do know that it's scored significantly lower by the council's own greenbelt review assessment, and yet somehow they've been treated equally when it comes to the greenbelt assessment. So that's just one. Sorry.
Yeah. No. Can I just take that forward a little bit in terms of that methodology, what Mr. Birkinshaw set out, and I know we touched on this. I forget which day. Monday, Tuesday. We weren't here on Monday, were we? I was in my mind. But would it, in that methodology, if the council did reach a view that there was justification for this allocation, would it, in your view, have been incumbent on them to set the value of the greenbelt here relative to other parcels of greenbelt value as part of that justification? And I suppose so that's the sort of principle. The second question is, have they done that anywhere through the studies that you've seen?
Yes, they had to somehow differentiate, because greenbelt harm is an impact on greenbelt purposes is a necessarily central issue when you're releasing land from the greenbelt and the exceptional circumstances test. So absolutely, there's a need for differentiation and comparative assessment. So you make sure you take that into account. You're not bound by it, but you have to take it into account. And I'm very happy to be proved I'm wrong in the 9 years worth of documents, but we can't find any comparative assessment of greenbelt harm leading to the allocation. We can see the comparative assessment in the stage 2 greenbelt assessment, which is document CSN 8.1. We can see the differentiation there, and it's scoring strongly there, but we can't see anything anywhere that follows that through in terms of why this site gets to the top of the pile. That's the point on greenbelt. I've got other points on.
So I was going to, if you didn't pick it up, I was going to ask you about the Stage 2 Greenbelt Review, which is CSN 0801, as you mentioned. Now, that does look at all the land around Tring, but from your perspective, just to be absolutely clear, there is then, as Mr. Birkinshaw was questioning, in your view, a lack of, okay, we've looked at these sites, we've looked at this one, where does the balance fall, where's the justification for TR03? Is that,
Yeah.
Okay.
And when we come to the Sustainability Appraisal 2024, it specifically says it's not making the allocations. It's providing the information to allow the allocations to be made. But there's a link missing, which is somewhere, either in SA24 or in the subsequent decision making, there's just a failure to comparatively assess the Greenbelt harm in accordance with the Secretary of State's decision letter. That's our key point on Greenbelt.
And just on that, it was a point that we touched upon on Tuesday, and again, I don't really want to go over old ground, but what would you say to Council's response that, well, if you look at ED 39,
yeah.
it does refer to Greenbelt, and it does refer to the evidence, and it does refer to, contributing strongly to the purposes of Greenbelt. How would you sort of respond to that?
Well, I hope I tried to do that just now. But if we look at page 114, I think it's the page you're looking at. That's the only reference to it. So it doesn't appear in the assessment of the conclusions at the end in terms of the significance of the Greenbelt harm as a sort of overall balance. But if we just look at the Greenbelt evaluation, it refers to the strongly. So that's right. My point is that the strongly leads nowhere. It doesn't lead to a red, so it's the same as if it contributes moderately or in a minor way to. So it doesn't go anywhere, and then and also we don't get in that Greenbelt evaluation box the Secretary of State's conclusions, which are pretty strongly against this site. So we're left leaving out a necessarily material consideration, namely the Secretary of State agreeing with the evaluation in the Greenbelt study and going further. 24 and 28 of the decision letter. And so it's correct that there's a mention of it, but where does it go in the analysis and in the comparative exercise? With respect, if you look at the third paragraph on page 117 within the box, the justification, that seems to be somehow relying on the decision letter as supporting the allocation rather than the inverse, which is that it supports the harm, the Greenbelt harm case, which hasn't been weighed.
Greenbelt was obviously a large part of that decision. So too was landscape.
Yes.
What does the Secretary of State's decision tell us, if anything, about landscape? And again, how does that, in your position, lead to a conclusion that the allocation is not justified?
Okay, well, it's the same exercise, I think. If we can we go to the decision letter at 29 to 31? And I think that's an adequate summary of it for the purposes of this discussion. You'll have read this already. You see at the end of 29, overall, taking into account the sensitive design and the development and proposed mitigations, that's taking into account all the requirements of the policy framework as well. He agrees that the harm to the character and appearance of the surrounding area should be given moderate rates. That's just the general position. And then 30, the appeal proposal would extend the built development, much of which would be closer to the sensitive receptors of the, national landscape area. He further agrees receptors in the national landscape area would experience adverse effects and there would be harm due to a loss of panoramic views of the NLA from public rights of way and tree planting and building and so on. He agrees that even with the existing proposed planting, there would be residual adverse effects on the setting of the NLA, to which great weight should be given. So that's the starting point. Great weight to be given to the harm to the NLA. And so one would be expecting to see that followed through in either the sustainability appraisal or in ED 39. And so if we look at sustainability appraisal, CD 3.1, at the tables that lead up to table 6.2, if we look at the landscape section, which is, sorry, I've just lost my reference. Yes, 6.13. We don't see any reflection of that great weight for the option 7 in terms of the TR03. I think 6.13.2 is probably the closest it gets. But look at the way 6.13.2 is worded. It's almost like forget the Great Weight because there's extensive parkland along the Grand Union Canal. The Secretary of State knew all that when he made his Great Weight decision. So it's inverting the Secretary of State's conclusions. And then we come to I'm not sure there's any other paragraph there that helps on this aspect in terms of Tring and TR03. So 6.13.2. And then if we go back, please, to ED39, and again, I hope I'm not missing any significant document in the trail, but these are the main ones, I think, for your purposes. And we look at landscape. Look at the way it's put in the box on page 114. May impact its setting due to proximity. I mean, a fundamental misconception as to what the Secretary of State was finding. It's not may, it will create harm of great weight. So the balancing exercise is simply wrong because the Secretary of State's decision hasn't been followed through. And then if we get into the actual text, I think I can jump straight to the text here. Yeah, if we jump straight to the text again, we see all the positives mentioned in paragraphs 1 and 2. We're told that there's been reference to the Secretary of State's appeal decision, but that's the no technical issues rather than the great weight to the NLA harm. And then we just see, well, it was refused on very special circumstances, and that's a different test. So it's not grappling with the substantive findings of the Secretary of State. And effectively, therefore, the Council has to be saying that we're departing from the Secretary of State. But why and how and for what reasons? And is it permissible to do so on those specific points? And then the third one is the best and most versatile agricultural land. Oh, sorry. Yeah.
No, not at all. You can I probably sound like a broken record at this point, and you can see where this is going. In terms of, same question really, in terms of greenbelt value, your point being, or a point being, that there should have been this comparative process or an articulated comparative process that led to TR03. Would you say that the same, in your view, should have been undertaken in terms of landscape sensitivity when we're looking at landscape value, when we're talking about the AONB in old money?
There's 2 points here, though. The first is the weight to attach to the NLA, whether it's harmful. And we know it is because the Secretary of State said it is. So it's an additional prong here. And so where do they consider the weight? And they don't. That's the bottom. ED39 doesn't assess that weight. And then, yes, on top of that, there should have been a comparative exercise with others to see whether this is the right site to release.
I don't know if you've got it in front of you, but I was looking through the landscape sensitivity study, which we talked through yesterday. And I know there are various flags up, and I'm sure we'll come to other people at some point. And that is examination document CSN 10.1.
So I'm really sorry to interrupt you. Would you be okay to turn your microphone off when you finish speaking?
Oh,
sorry. No, it just means it's showing you on the camera as opposed to Mr. Bristow.
Yes, so we don't want anyone suggesting that what I was saying was coming through your microphone. In terms of the landscape sensitivity study, I don't know if you've got it in front of you. That's examination document CSN 10.1. And I just wanted to ask a question from your perspective about that, given that this comparative process comes through very clearly in terms of the representations that Grove Fields and you have articulated. If we look at on page 6, I think it is, and figure 1, of course, yeah, absolutely. It's the map. I think it's figure 1, page 6. Is that right? I'm seeing a nod there. I'm seeing some. Okay, there we are. So I was representations and how the representation of others. I was looking through to see what process was gone through, and indeed we have asked questions about that previously. In terms of landscape sensitivity, if I look at that figure, it seems to be that unlike the greenbelt value assessment, the scope of the landscape sensitivity study was to look at specific parcels, not, for example, the entirety of land around Tring. And I just wanted to understand, to clarify, I suppose, my understanding of that, which we will, of course, come to the council in due course. But is that your understanding as well, that in terms of purely landscape sensitivity, so setting aside greenbelt value for a second, was there an assessment of other areas around Tring to arrive at a reasoned judgment that TR03 was, for example, the least potentially harmful? Have you seen anything in that space?
No, I haven't seen anything like that, but you'll notice on this plan that all of the allocations are assessed, both here and in Berkhamsted. So our point is not, I think, that there's a better site for a major allocation in Tring, but there's a better site for, there's a properly assessed other sites elsewhere, namely Berkhamsted and Hempstead would come higher up the score, would score better.
Okay, thank you. And you were going to go on to best and most versatile agricultural land, I believe. Sorry for
the same
waylaying
point,
us.
The same point arises. I think it's the decision letter paragraph 32, I think it is. Significant weight, you see there. And in the essay 24, that is assessed as well. I can find a reference for you. There's a heading soils, but here we go. Soils at 6.12 on page 59. I don't have any gripe with that. I mean, it basically says that there's a problem here. But if we go to ED 39, we look at where does the Secretary of State's conclusion follow through? And if we go to ED 39, page 116, right at the top, you'll have seen me referring to the double cross in red for soils almost uniquely, and this site is the double cross red. So it's referred to. I get that it's referred to, but then where is it followed through in the reasoning at page 117? And where do we get the significant weight the Secretary of State referred to? Where do we see that being reflected in any of this analysis? And so my point is my point is very specific. It's about those three matters. It's about those three matters. There's been findings. There, as a matter of just basic policy and principle and case law, they should be, those conclusions of the Secretary of State are necessarily material. On all three of those matters, the very significant harm on those matters has not followed through into the allocation decision. I mean, that's our case.
Final question, and then I'll turn to the council for their response to a lot of this. And these are some of the points the council have made, is that landscape evidence has been produced by the council in support of the local plan, which grapples with the landscape issue, and it refers to moderate to high impact, etc., etc. They've also done a greenbelt assessment, and we know what that says about contributing strongly to purposes. So they've done pieces of evidence which tend to sort of correlate with the inspector's recommendation and the Secretary of State's decision. I don't think there's a massive level of disagreement there. What you're saying is that they haven't then sort of pieced this together and come up with a sort of cogent reasons as to why, in their opinion, in their judgment, the allocation is justified. Is that something, in your opinion, that could be rectified through the examination process? So could the council go away in response to us and do some work and say, look, we've got the evidence. We're not hiding behind the evidence is there, and do the sort of the evaluating and the balancing, and come up with a paper that says, look, in our judgment, in the process of allocating sites to meet a housing requirement in a local plan, having considered reasonable alternatives, we think this is an appropriate strategy.
Yes, absolutely. But they would need to do it without any pre-ordained constraints. So things like the exclusion of east of Berkhamsted would have to be back on the table. They'd have to think about it afresh, and they'd have to do the exercise that you asked them to do last time around, which was pulling it all together into a where is the narrative. I'm sure they can come up with a narrative to try to justify any particular decision, but they might have to decide that this isn't the right site. They'd have to come up at it with an open mind. And when they did the exercise, they'd be led by the evidence, and they might have to put a main modification forward that removed this site and put another one in. I think that's as far as we would want to push it. I mean, we're not for 1 second saying the plan should fail on this basis, because this is a limited point. And it's about one element of the overall strategy. But obviously, from my client's perspective, it's a fundamental point. We're not challenging other allocations. We're not challenging other elements of the plan. We're saying this bit of the allocation process has taken a wrong turn, and it needs to go back a stage and do the exercise either from the SA24 or perhaps more properly a follow-on from SA24. Because if you look at SA24 itself, it says specifically, I can't remember the page reference now, but it says this is not making allocation recommendations. And so maybe there's a stage that is required which pulls together SA24, pulls together the Secretary of State's decision letter and all of the historic figures, and then does the exercise that is table 6.2, but does that exercise on a weighted basis and including green belt, because obviously table 6.2 doesn't include green belt at the moment. And then we would say it has to go one stage further and has to look at the spatial strategy in terms of disproportionate growth as well. But but it was said the other day that there's no magic formula for all of this. And I'm not pretending you can do an algorithm or anything like that on this sort of issue, but you just got to make sure you thought about it in a logical framework where you're weighing issues appropriately. Remember, table 6.2 is not weighted; it's expressly not weighted at all, and so all of the elements count equivalently. So no weighting, no comparative exercise. Something's gone wrong that's led to this allocation. That's our point.
I slightly hesitate, but given that you're on the digital line, I'll ask. I mean, we know that there is obviously a planning application has been made, which I'm sure the council will cover, and Mr. Birkinshaw has explained the distinction between what we're doing in terms of a local planning examination and a Section 78 and the Secretary of State decision. But in terms of, say, the area of the site or the nature of the development proposed, is there, in the Grovefield Residents Association view, any significant difference between what we are invited to consider as allocation, TR03, relative to what was proposed via the Secretary of State decision?
No. But certainly not via the Secretary of State's decision. Maybe this application, the current application does try to go a bit further. I think in the statement for the landowners, it does say that they've tried to go further in terms of the landscaping between the housing and the sang. I think that's said, but the significance of that in terms of the harm to the NLA, I haven't seen an assessment of that by the council yet.
Turn to council then, just on those sort of critical points around, and again, it does touch a little bit about what we talked on Tuesday, but just those are critical points about how, where, and when you really sort of factored these issues into account where it's set out in the evidence, where we can find that logical sort of flow through from, yeah, we've done this evidence, it says this, we think that, and therefore it's justified allocation.
Sir, I'll allow my colleagues to the left to deal with those specific questions, but I hope you don't mind me taking the opportunity just to speak about questions of legal approach and correctness, because just concerned that the hearing shouldn't be misled, not intentionally, but by the submissions, in particular those in writing on behalf of Grove Field. So if you'd allow me to do that, I hope it'll be helpful. I don't think you need to turn to the statement, but you'll have in mind that it refers to case law and in effect constructs an argument to which Mr. Forstig has made some attempt today to use as a touchstone, but in fairness, not entirely completely so as to complete the circle. So it's necessary, because you're going to take away that document, for me to make the following comments on it. The first point is this: I don't think this is disagreed, that the local plan process is separate to and distinct from that of the Secretary of State, and indeed different from any decision-making in the development control context. Nor is it, I think, disputed that there are different tests. But what isn't conveyed is the significance of the different tests. So your role, our role, what we are here trying to do today is to examine the soundness of the plan. We're not here to consider any particular proposal. Under, for example, section 38.6, we're dealing with paragraph 35 of the 2023 framework and the question of soundness. And that is a very different context, which in effect drives right through Mr. Forstig's submissions. If you keep that in mind, you will not be misled unintentionally by the submissions he makes in relation to the importance of the Secretary of State's decision. Having accepted, at least in broad terms, that there are different tests to be applied, the allegation or the suggestion, it's not made entirely clear in paragraphs 8 and 9, is that there is some legally binding proposition at large in relation to the decision or elements of it. That allegation or suggestion is simply not correct. And there are a number of reasons for that. First, the decision does not bind the decision maker in a local plan context. Secondly, the tests are very different. The Secretary of State dealing with an entirely different governing test of very special circumstances in relation to a particular proposal before him, as opposed to whether or not a policy and allocation for residential development in accordance with the policy is justified, effective, and consistent with national policy. The question of soundness. Grove Field's written hearing statement refers to the different tests, but curiously doesn't tell you what the difference is. I suspect that Mr. Forstig would say, well, that's trite, because you should know that, and of course you will know it. But it is important, actually, to include it in any submissions which are laid before you. He will not be able to dispute, and you will know perfectly well, that the test of VSC is more strict than that of exceptional circumstances. Pretty important point.
going again to his argument that the Secretary of State's judgments should feed through and, in effect, somehow bind the authority. Again, there is case law to support that, the case of Luton, and should you wish it, we can provide it. It's not referred to by Mr. Forsdick. It could have been, and with respect, it probably should have been. The other thing that case law makes clear, and it's important to have this in mind, is that we're dealing here with matters of planning judgment. The exceptional circumstances test, in particular, is ultimately a matter of planning judgment. People will have their differing view, and it will be highly fact sensitive. So the fact that the Secretary of State, in relation to the stricter test of VSC, has formed some view and determined a judgment on a particular proposal set before him during a long inquiry with, no doubt, voluminous evidence of a particular proposal in all its elements, tells us little, certainly doesn't bind us here today as to whether or not exceptional circumstances are made out or whether the allocation is justified. The second main reason that I want to make clear is that even if there are circumstances where a previous Secretary of State's decision has been made on the same point and in respect of the same facts, not the case here, such that the principle of consistency in decision-making arises, that doesn't bind the second decision maker to reach the same conclusions. Rather, in accordance with case law, it establishes that the first decision is a material consideration to be taken into account, which will need to be reasons given for any departure from it. So a later decision maker can reach a decision that's different, so long as there are either material changes in circumstances or good reasons are given for it. And that's, again, established in law. If you'd like the case, North Wiltshire is probably known to you, we can provide it. We don't fall into that situation here. This is not a case where we are dealing with materially indistinguishable circumstances. We are. We're dealing with a very distinct and different policy context, about which I've already addressed you. And we're also dealing with a question about soundness for an allocation without a particular proposal before you. And that's the whole point. The point is not, is there a particular proposal where the Secretary of State's judgments should have some binding effect? The question is this allocation sound for the purposes of the development proposed in the allocation? In other words, as you put it on a previous occasion, we're dealing with the principle of the development on this site, governed as it will be by the policy words and the criteria. We already know that there's a new application. The Red Road statement refers to it. We already will know, should know, that any new application that comes along, consistent with the allocation, if the plan is adopted, we'll have to set out reasons in order to meet the criteria in the policy. But that's a very different exercise from that before you today. So it's not that the authority is not looking at the Secretary of State's decision as a material consideration. It plainly has done, quite clearly, and that's not disputed. So far as the
particular elements to which Mr. Forsdick referred to today, greenbelt, landscape, and soils, just stand back and remember that actually what I think Mr. Forsdick was driving at was a criticism, much of which we've already discussed under methodology, of the judgments reached by the authority. Actually, those don't depend upon reliance on the Secretary of State's decision, and nor should they. This isn't a question of judicial review. It's not a question where we should be picking at judgment and saying, why didn't you follow the Secretary of State's finding on that particular matter? The Secretary of State was looking at a different question. Secretary of State, as with the inspector, was looking at a particular proposal with all the elements before him, not looking at the question of the allocation. So when Mr. Forsdick referred to passages in the Secretary of State's decision, for example, 26, overall, the Secretary of State agrees the harm to the Greenbelt, that's harm arising from the proposal before him. The exercise carried out by the authority and for you is to determine is whether or not the allocation is sound by reference to the value of the Greenbelt for the allocation. And the allocation is not a particular proposal, because proposals may differ. The final point is this, just for your note, is that the Grovefield Residents Association submission also cites two authorities. Suffice it to say, the first, Evans, is not relevant. That concerns a court decision binding on the executive. That's not the same principle which Grovefield seeks to assert. And the case of PowerGen is likewise not relevant. That deals, as you will know, sir, with where an executive decision has been made, and the question is whether a different executive body can choose to ignore it or comply with it. I've indicated the relevant case law that you should have before you, and I've also drawn attention to the irrelevant case law. So far as the detailed methodology is concerned and the concerns about that, you have already heard a great deal of information about that, but I know that there are one or two particular points that Mr. Lathan and my colleagues to the left would wish to add. So if you'd like any further information as to the correct legal approach, I'm happy to provide that. Otherwise, I hope those submissions are clear and helpful.
Thank you. I've got 3 or 4 points to make just on response to the answer to your question, sir. Firstly, the sustainability appraisal has considered soils, landscape, and also green belt. So if I point to paragraph 5.2.58, CDO 4.1, says a key work of exploring reasonable growth scenarios was to test ways to respond to the findings of the Stage 2 Greenbelt Review, striking a balance between Greenbelt sensitivity and wider sustainability objectives. This remains a focus of sustainability appraisal work. And then the Welwyn Local Plan Inspector's report is quoted, stating that sites which cause least harm to the Greenbelt, openness and purposes, while at the same time favouring those that score best from a sustainability perspective, could be opposing forces, in which case a balance would need to be struck according to the weight of the evidence. Then point to ED 39, rather, so that considers all of those constraints. There are justifications provided from 2020, 2023, and 2024. So I tried to keep it as succinct as possible, and I realise we discussed that it is quite packed in terms of what a logical and comprehensive extension would be with sustainable patterns of development and new enhanced links to the station. That does cover the range of benefits which are listed in more detail within the 2020 justification, and we still recognise the other sensitivities and constraints within that study. I also want to point to, I know we're speaking of mission sites here, but in terms of the assessment against alternatives, on page 120 and 124 of ED 39, it covers the emission sites, other emission sites in Tring, which talks about why they weren't selected for allocation, looking at their contribution or to sustainability objectives in comparison to the alternatives within that settlement. And then my final point regarding the other sites mentioned, we do have moderately performing greenbelt sites. Within Berkhamsted, there are assessments within CD39 which state that they were not taken forward due to the prevailing infrastructure capacity constraints within those locations. And then turning to the East Berkhamsted site on pages 101 to 105, it actually identifies that our landscape evidence assessed this to be of a high landscape sensitivity, so more harm than Tring 18R, as well as a strong contribution to the greenbelt purposes. And then the justification at the end as to why this site was not taken forward is that the benefits it could deliver, recognising those, would not be outweighed by those harms identified within that evidence. So while we didn't undertake a weighted scoring evaluation, I do believe that not doing this can provide us with a more complete, accurate understanding when all these sites do have different complex contexts where we don't have objective metrics, clear objective metrics to apply within an evaluation. I think considering the benefits and the harms individually on the round would be more effective. I believe that's what we have achieved within our additional evidence.
Thank you. If I may, just a very short additional point, if I may, and it's just a very, very high level one. I think one important point is naturally we've had a lot of discussion about the nature and purpose of the SA already through earlier stage hearings. And first point on that is we have highly competent professionals who've progressed and undertaken that, and the approach that they've taken to the SA for this plan is not in any way, in my view, inconsistent with the approach that has supported and informed a wide range of successful local plans elsewhere in the country. In addition to that, there was a reference to the consideration of other sites elsewhere. Sites at Hemel, which we discussed yesterday. And I note that very much there was no one really seeking to have this, there was a very small number of sites looking to be in the plan, and they weren't really going to deliver much in terms of homes or indeed wider infrastructure. I think that yesterday and the previous day on North Hemel is demonstrable of how much growth we are looking to allocate at Hemel. Professionally, I don't think there's much more we can do with Hemel to what is already within the plan. In terms of the scale and proportion, it is 68 to 70% of the overall growth. And that includes land being released from the greenbelt, land that contributes strongly towards the purpose of the greenbelt, land that contributes highly against, in terms of landscape sensitivity, we've discussed that it can be high, moderate and high, in terms of our evidence, and the same evidence we use for this site. When it comes to Berkhamsted, we've yet to discuss Berkhamsted sites and the allocations, but notwithstanding that, I did make some point, clear point. I think that there's wider considerations to the Greenbelt debate at Berkhamsted. But in any case, a point about, or maybe other sites that are perhaps less sensitive in landscape terms, and probably squaring the circle on this, taking it back to the SA again, and that table 6.2. We do test lower growth at Tring, or at the SA and the consultants considered lower growth to Tring to what is in the plan. That is in scenarios 1, 2, and 3. But also it tests a higher growth scenario at Berkhamsted through scenario 3. And that, in my view, demonstrates that if you remove some landscape harm from one part, you are in essence, as part of that consideration, putting it somewhere else in the borough within the setting of the national landscape also. So you're in essence removing one place, but you are potentially considering putting it in other locations. But you'll also look at that when you look at scenarios 1, 2, and 3 with regards to homes. Scenario 1 and 2 and 3 all perform less when it comes to the number of homes that they would deliver. So it's the nature of the essay is to consider that. It can only really appraise that by having a narrative and discussion in the context of sites, and we've discussed that at length, but to come to that overall kind of conclusion and to inform our final recommendations, we've had regard to, you know, the various kind of scenarios put forward on that. And I think, you know, being very, very clear that the Council's response to Matter 2, Issue 2, Question 4, and Matter 2, Issue 3, Question 4, set out the strategic approach to considering the implications for the setting of the Chilterns national landscape when selecting sites in a manner consistent with its statutory duty and the framework, and that this approach is supported by Natural England, that confirmed it is content that the current growth scenario can adequately mitigate adverse impacts on the national landscape. That's set out within the Regulation 20 representation, ID 360. So we're probably cutting across some wider matters here, but I think it's just with regards to with Greenbelt and with the discussion of what we've talked about in landscape, we'll probably come on to some of these points in a bit more detail. But I think it's just setting some of that kind of macro level discussion again and putting that into the context. Thank you, sirs.
Just final question, then we're going to take a break. And this is directed at Growfield Resident Association, and we'll take a break, and then I do want to hear from some more people. And I don't want to get into sort of tit for tat really on case law and all the rest. I did say at the very start, we are well aware of the situation that we're in. We're well aware of the position that Mr. Bristow and I are in compared to our colleague in the appeal decision. So I don't want to get dragged back into that, because we did say at the start, we've got a clear understanding of that. What I do just want to finish this topic on is when you, obviously, the Growfield Residents Association and others have critiqued the council's sort of methodological approach to allocating this site, and we spent an awful lot of time talking about this in this examination. Ultimately, what you said, your position is that the council could, and it was within their judgment to allocate this site, they could go away and do this process of you know, more thoroughly, in your view, looking at the issues. And maybe ED 39 could have been more extensive, and it could have clearly, you know, spelt out various levels of harm, etc., etc. When you read ED 39 and the entire examination library as a whole, it is clear, is it not, that the council were well aware of the issues. It's not a case, I don't think, unless you can point me to something that says that this is different, that the council got it wrong on one of these issues. And we'll come on to talk about landscape after a break. But you're saying that, well, the council could go away and they could sort of bulk up ED 39 and they could say, yep, the green belt, this land contributes strongly to green belt purposes. Well, they say that, the evidence says that. So that was in their mind when they were making their decisions on which sites to allocate. They knew that because it's in their evidence. They also know about the landscape sensitivities of the site, and ED 39 refers to. It says in, I think it's in the 2020 or 2023 justification, you know, we're well aware of the landscape sensitivities. What they're saying is, we're not regurgitating all this evidence. ED 39 was very much a sort of summary of their thinking and a summary of their thoughts as trying to show us how they got there. And ultimately, what the council have said is, you know, in regards to Tring, they talk about it's able to deliver a comprehensive urban extension. It talks about the benefits of that proposal and of that potential development. It talks about the enhanced links to the station, etc. So it does, in the evidence, refer to some of the benefits that would arise. Yeah. On that basis, why is ED 39 and the evidence as a whole so fundamentally flawed that we should task the council with going back and doing an exercise and spending a lot of time doing an exercise, writing things down that they've already written down to potentially come out with exactly the same outcome?
Well, that's the word potentially is carrying a lot of baggage there. Potentially come out with the same outcome. Of course, it potentially could come out with the same outcome, but methodology, transparent and robust methodology with decision-making properly framed is fundamental to soundness. And you say, well, somewhere in the papers we can find the Greenbelt analysis and somewhere we can find the NLA analysis and stuff. I'm not disputing that. And we never have disputed that. Where the methodology has gone wrong is that it isn't pulled together. And a justification for this site versus other sites is not provided. So we look at SA24 and we know it's not making allocations. It's not making the decisions. We know that at Berkhamsted, it put forward 4 options, which included the sites we say should score better. So we know the SA24, the Sustainability Appraisal 24 was part of the journey to the answer. We know there isn't the intervening assessment at the time in any document that we've been provided with to show how you get from SA24 to the local plan. So that's a fundamental gap. It's a fundamental logic gap. The opportunity was provided exceptionally, and we criticised this in our statement from Tuesday, that somehow that ED39 is effectively retrofitting the explanation that should have come following the sustainability appraisal. But then, therefore, you need to look at ED39 and see whether it does the exercise that should have been done before the plan got to Reg 19 stage. And it doesn't. It doesn't do either a weighted exercise, nor does it consider the Secretary of State's decision. And I would need to come back to some of the points that my own friend made on that very shortly. And it doesn't come to, so it doesn't do the weighting, it doesn't do the Secretary of State decision, and it doesn't do a comparative exercise with other sites, which is exactly what it was supposed to be doing. When it gets beyond the sustainability appraisal, which left those matters up for grabs. And so I accept that there is a possibility that when this whole exercise is done properly, with a proper weighting and comparative exercise with the right inputs put into the mix, then this site might come through. But the whole point of this process in front of you is to test the methodology and to test the logic of the process. And if the inspectors could simply say, well, it might come up with the same answer anyway, there's no point being here.
Because that's the point that the council's position, and obviously, you know, we need to go away and sort of carefully consider what we've heard this week, and goes back to Tuesday especially. The council's position is very much, we have done a proportionate exercise, bearing in mind that we're in a local plan preparation. We've got hundreds, if not thousands, of sites before us, and we have gone through a process and commissioned various documents, and ED39 presents at a sort of summary level why we think this site is justified, why it's an appropriate strategy, and why it meets the test of soundness. We're not into the sort of planning appeal territory level of detail. Yet they recognise landscape sensitivities. They recognise strong contribution to greenbelt purposes, but ultimately reached a view in their judgment as to why they think this site's justified. So that's their position. Their position is strong greenbelt impact, landscape sensitivities. All of that's out there. All of it's publicly available. We know all of these issues. Okay. Now we've taken all this into account, and we still think, as a local planning authority, that this site is justified. We've got to meet housing need. We've got to meet a housing requirement. And you look at ED39, it talks about some of the benefits of this development in their opinion, and we can disagree. People disagree. So what's fundamentally wrong with that?
What's fundamentally wrong with that is that we can see the justification for this allocation in the 3 paragraphs in page 117. And those 3 paragraphs fundamentally miss the point. That they just don't grapple with the fundamental issues here, namely the weight to be attached to the greenbelt harm, which is just, it's orange, everyone gets orange, so therefore the major problem with this site is left out of account. They don't reflect the harm to the NLA, which has been found by the Secretary of State. That's nothing to do with whether it's a planning application or it's an allocation. It's the same issue. They don't reflect that, and they invert the Secretary of State's reasoning as somehow supportive of this, whereas in fact, when you disaggregate it into its elements, it's clearly not supportive. It's putting three major elements into the pot that they don't treat as major elements. No, I'm not going to do that. But I was very careful in my note to not do what I'm accused of doing. If you read my note carefully, it doesn't say there's a binding. That the Secretary of State's decision is binding. It says it's a necessarily highly material consideration. It doesn't do any of the things I'm accused of submitting to you. I think it's common ground that the Secretary of State's decision letter is a material consideration. I say highly material. And that if you're going to depart from it, you need to have good reasons. And where are those good reasons? So the criticisms that were made just don't reflect what I'm trying to say in my note.
Not at this stage, no, I think.
So can I just, if just before the break, just make two very short points. One is a point I made yesterday and I've made before. Paragraph 35 is dealing with proportionate evidence. ED 39 has been mischaracterized. It is intended to assist you in providing that succinct commentary. It shouldn't be read, obviously, in isolation. And it really is hearing submissions about nitpicking on the 3 paragraphs, side swipes like that, it's frankly not fair. Secondly, the idea that we should go away and carry out what is going to be, pretty. What would be the point? It's not said that we didn't reach those judgments. What is said and invited is some weighting exercise going to considerable detail about the question of allocation along the lines from essay table 6. But putting weightings on is not going to change the judgment that we've already reached and through proportionate evidence have explained it to you. Those are the only 2 comments. Thank you.
Okay, let's take a break because I do want to return to, I want to sort of involve others in the debate as well. The second question was around the spatial strategy. And really that question is in MIQs to allow other people who weren't at that session on matter 2 to sort of have their say on that. We have heard a lot about that. We've heard a lot about it on spatial strategy. We've heard a lot about it on essay. We've heard a lot about it on Tuesday as well. There's more an opportunity for those who weren't at previous sessions to have their say. But we will take a break and we'll come back and we'll touch upon those. And then we've got some questions on sort of landscape impact as well. So we'll adjourn, we'll resume at 20 past. Okay, thank you. Okay, thank you, everyone. We'll resume and continue. So, what I want to do, probably next hour or so, maybe it's lunch, is the remainder of TRO3. And what I want to concentrate on, if you turn to the matters, issues and questions, question 2, I feel like we've heard an awful lot on, and we've got people's written representations on that. And this is this whole issue about whether or not TRO3 is justified and consistent in regard to the spatial strategy. Mr. Bristow and I have got a very clear understanding as to people's views on that. So unless there's anything that anybody hasn't raised or any new points that we've not actually discussed, because we've had a whole session on spatial strategy, we've had a whole session on the essay, we've had 2 sessions at least on site selection methodology, we have a really good understanding of people's views on that. What I do want to spend a bit of time instead and concentrate on is actually some of the specific details of the allocation. So, really, the questions around the site boundary, the site boundary and the areas of land to be retained in the greenbelt and landscape all sort of probably merge into one topic that I want to spend the next sort of part of this hearing trying to understand in a bit more detail. So, to hand over to council, really, there's a bit of a merging of the MIQs here around the site boundary, the areas to be retained in the greenbelt and the landscape impact. So, in terms of, again, let's just separate ourselves from a plan application and a local plan, strategic land use document. How did the council come about establishing A, the site boundary and the extent of the site allocation, and B, the areas of land that would be removed from the greenbelt or retained in the greenbelt, and just try and help Mr. Bristow and I understand the reason and the rationale behind those 2 sort of components of this site.
So, question 3, the wider red line boundary, that was based on the area that was promoted, the extent of the land that was promoted by Barrett Redrow. And then within our statement of common ground, which is ED 24, that confirmed that the site isn't subject to any insurmountable ownership constraints that would impede that development. So it's an iterative process informed by engagement with the site promoter. The Stage 3 Greenbelt review, which I won't repeat, sets out where the red line boundaries of the site are, and that assessed that. Then, following the production of the Stage 3 Greenbelt review, we had an area proposed as SANG that runs along the boundary of the site, the Grand Union Canal, down the length of the site. Probably go into more detail actually within question 4. So paragraph 5.18 and 5.19. We set out a strategic justification for why we would retain SANG land within the greenbelt within our earlier statements, which we discussed Tuesday. Now I'm saying Monday, Tuesday. And then within that, we're saying the land to be retained within the greenbelt. The new boundary would basically be defined by master planning, landscape considerations, biodiversity, net gain, biodiversity and green infrastructure requirements within the site allocation policy. So the new greenbelt boundary would be where the edge of the SANG is located. I don't know if Ronan, you've got anything to add on the kind of...
Nothing of much detail that, just to note obviously our approach and what we discussed yesterday with regard to HM11 and I think it was HM13, Polehanger Lane and Shendish Manor, the approach to how we seek to secure SANG and keep it as a natural green spaces and that's going to be kept in perpetuity for at least 80 years is the approach to those sites is no different for this one. And just in addition to that, notwithstanding kind of wider concerns, but with regards to the Conservation Board, and recognise that we have Dr. Thompson here today, he recognised if this was a sound allocation, or was to be a sound allocation, that our approach to keeping that land, I think, within the greenbelt, the SANG, would be, an appropriate approach.
saying within our response to question 6 that the SANG within the red line boundary functions as a buffer on that eastern site boundary with the Chilterns National Landscape.
We've heard a lot about sort of purposes of green belt and landscape sensitivities. So obviously you said that the red line's based on the site that was promoted, and we've talked a lot about this, haven't we? About the purposes of or the processes, sorry, of local plan preparation and considering the sites that come before you. Talk us through the council's process, having received and considered a site allocation or a potential site allocation. What did you do, or sort of where did you go in your evidence to then consider things like landscape sensitivity? So where do we see the evidence where you've grappled with this issue in terms of landscape especially?
Within question 6, or response to question 6, I refer to the healer. This was mentioned before, where the healer, so paragraph 5.38, the site would likely impact the setting, just to flag that the healer is a technical study. It's not assessing proposals. It's assessing constraints. That detail is set out within our response to matter 2, issue 3, question 4, the kind of overarching approach taken by the healer in considering the Chilterns National Landscape as a potential major constraint, potential constraint to these sites. We then have the landscape sensitivity study, which is CSN 10.1. Let me know when you've got this.
So just so we can piece together the sort of timeline on this, you've done your calls for sites, you're considering potential site allocations, you've gone through the HELAR process, that sort of again sort of initial sifting. Where does the landscape sensitivity study come into your overall process and thinking about which sites to allocate?
I guess I do a broad chronology point just to flag that the HELAR conclusions of 2024 take forward conclusions from the 2020 and 2023 study. So that was the site assessment studies from those points. Whilst the 2024 HELAR we consider the most up-to-date position, landscape was considered in detail through the previous site assessment studies as well. And then the landscape sensitivity study, which was prepared in 2020 as well. So published alongside the first, we call it the rural SLAR, it's the ACOM site assessment study to inform the proposed allocation within the emerging strategy for growth, Regulation 18 consultation.
Okay, so that was alongside Reg 18, and then what does that tell us then about Tring and potential options at Tring?
So it's the assessment for east of Tring, starts on page 201 of CSN 10.
Let's just go one sort of tiny step back. The purpose of the study and its content, what does it consider and what does it not consider? So which sites does it take into account at that stage? What was it considering? Was it sort of considering reasonable alternatives? Was it considering all sites? How did you sort of narrow down and focus on the sites it was going to have a look at?
And I'll just mention that this, comes back to a point I think I raised to Mr. Forstick in terms of, well, what was the scope? Was there a consideration of other parcels around Tring?
Thank you, sirs. It was prepared in 2020, and as I referred to earlier, we haven't received a whole lot of really substantial new significant sites since 2020 as well. So in terms of the need to update or consider more, I still think it's, you know, a robust piece of evidence. It does consider more sites than were recommended to be allocated in 2020. So it did consider a wider range of sites in the Greenbelt. And for Tring, it did include all of the sites that were within this area that we did recommend to be included, but it also included probably wider sites in other parts of the council, of Bovingdon and Kings Langley and up in Margate also. And also at Hemel Hempstead. So it does consider a wider range of sites, not just the sites we had recommended at the time, but it was at a point in time also. But you, I think, made reference to, I think, figure 1 within that on page 4, which set the scene for what sites it considered. So in addition to that, probably is going on just in terms of what it considered 2 kind of key components: the sensitivity of the site in landscape terms, but also its susceptibility to change. And in light of that, you know, the outcomes are broadly suggesting, you know, things are in the realm, you know, from the vast majority of our sites, it'd be easy for me to say that we are in the realm of moderate to high sensitivity across many of our large, you know, Greenbelt site applications. And just as a final point about, you know, a next step, we do have made reference to ED 39 as something that's being prepared by the council, you know, to inform these stages at your request. But that evidence did inform our previous iteration of that comparative, you know, summary, which was PCD 05.3. That was our appendix B to the site selection topic paper. And within that, we did have a landscape line, we will say, that summarized, you know, what the overarching conclusions were in relation to landscape. We also had a separate line for Greenbelt. And the approach, you know, 4, 5, 6 years on, you know, we have sought to refresh that document. So what I'm saying is, we considered it, you know, we took the outcomes and we looked at all the sites as much as we could, and we came to an informed judgment ourselves on what each site was. That was at 2020 with the same evidence that we have today when it came to recommending the sites for allocation and Tring then.
Yep, no, that's working. I think just to go maybe one step back, just to respond to the question about parcels as well, I just want to flag that the methodology section of CSN 10.1, which is section 3, page 4, states essentially what the methodology of the study was developed and what informed this. It did include the earlier outline landscape appraisal, which was done as part of the stage 2 Greenbelt study. And that was a broader parcel scale as well. So then this kind of clarifies it into site boundaries, but there was a broad landscape consideration done as part of the stage 2 Greenbelt review. As part of, I guess, my desire to want to keep things succinct, I referred to the landscape sensitivity study within ED 39 as the most up-to-date and site-specific consideration.
Can I just follow that through just a little bit? And sorry, Mr. Birkinshaw, if I'm going off the point, but say let's look at ED 39, which also has sites that are not taken forward. And I'm just picking an example. I'm not saying this is, just want to clarify my understanding. And if we're on, say, digital page 118, which is hard copy page, also 118. When does that ever happen? And we're looking at Tring 020R, which is land north of Icknield Way. I hope I'm pronouncing that correctly. If you look there, and we all know where that is on a map, that comes out with an amber rating, if you like, for landscape. That wasn't one of the sites specifically considered in the landscape study of April 2020 we've been talking about, CSN 10.1, we can see that it's not there in terms of a figure considered. So that justification for landscape effects then draws from the HELAR, which is SSA 014. If we go to that and look at land north of Icknield Way, it talks about landscape constraints. It doesn't necessarily cross-refer back to the Stage 2 Greenbelt review, I can see. The Greenbelt concluded the wider parcel. So it talks about the Greenbelt Stage 2 in terms of the Greenbelt. Well, I suppose my question, and this is just in terms of the comparative assessment that's been done, where we're looking in the HELAR in terms of landscape constraints, where is that position evidenced? Where is that from, given that there is evidently not the same process that's been undertaken of sites that are allocation?
So that site was considered, again, within the 2020, conscious not to turn my head, was considered within the 2020 rural SHLA prepared by ACOM. Now ACOM had their own kind of landscape consultants assess sites at the time. So that's document SSA 03.3. That's where you'll find, I don't have a page reference, but I know Ronan's looking for it for me. It wasn't recommended for further testing. So it wasn't assessed in CSN 010.1.
And was it, so I'm frantically going to the rural SHLA, which I know we've referenced and I've looked through extensively. So your point there is the rural SHLA, and I'm sorry if I'm getting too much detail, and Mr. Birkinshaw, please do bring me back to the point if I am. The rural SHLA knocked out, if you like, this, or provided the basis on which the council did not progress land north of Icknield Way. Did the rural SHLA provide also the basis for which land east of Tring continued to be recommended by the council as an allocation? And if that is the case, so I saw some body language there, can you point me to that very specifically? That would be useful.
Thank you. So the rural SHLA is let's say, the first of, and has been kind of subject to review and update as we've mentioned in previous ones. With regards to the specificity of it, I would just say that you've been provided with the reference to the document. So for the context, land north of Icknield Way, which was the one you've referred to, I think, within our ED 39, is on PDF page 264 of that appendix. And that includes on that page, it's hard copy page 166. But within that, there's a row on that, a specific landscape and visual impact that gives, I think there's 8 or 9 lines of detail from ACOM's consultants with regards to that site. And indeed, they looked at each and every one of those rural sites in that manner and gave their view on that. So we did take that into account. We also, needless to say, in addition to it, have been out on sites and have been reviewing and surveying as part of that process too. But, you know, on the recognition, they did have, you know, expert consultants involved in the preparation of this document. At the time, it was wise that we drew upon that.
Just in terms, just really specific, and I know I'm going into too much detail and we want to bring it back, but just in terms of the 2 sites that we're talking about, east of Tring, north of Icknield Way, as I see it from that rural SHLA, the grading in terms of the potential impacts on the Chilterns AONB is the same. Is that right? Yeah, this overall, in both instances, the sites judged perform reasonably, but with major constraints. Okay. Is that correct? Okay, thank you.
Okay, let's look at what it says about the land use of Tring. So don't want to get dragged too much back into site selection methodology, which everything keeps going back to, which we certainly don't want to spend any more time on. Let's look at the actual site. Let's look at what your landscape evidence says. So we know that land use of Tring has got into the 2020 landscape sensitivity study, the ARUP report. What does it then say about this site? And critically, what did you then do as local authority with that information?
So in a high-level summary, CSN 10 identified that overall the site has a moderate high landscape sensitivity. That was performed on the basis of an evaluation of the landscape value and then of the landscape susceptibility. Do you need a page number? Page 201 to 206. CSN 10.1. So the evaluation of landscape value comes first, then there's a assessment of different criterion for landscape susceptibility. That's undertaken the same way for all sites by the consultant, so looking at the landform, character, perception, scale, skylines and views. The overall susceptibility to change came up as moderate high. Then there was some consideration following site visits, and then finally on page 206. So there's no paragraph numbers, I'm afraid. It's one underneath overall landscape sensitivity subheading. It says overall the parcel is assessed as having a moderate high overall sensitivity to change. With reference that reduced intervisibility caused by lower and flatter topography and the field pattern. So it judged both field parcels separately, saying they both have moderate high, but for different reasons, essentially. So one for kind of a more open character and one because of the more intricate field pattern. They say there's a reference following that to the assessment of the wider Greenbelt parcel, or Greenbelt assessment stage 2, which looked at the parcel scale, found that one parcel was medium and one was high, so their justification for that is in line with it. And then there are a number of design response points and proposed mitigation for what development should consider. So within policy TR03, we've got 7 detailed site-specific landscape considerations, and that is on page 166 of CD 01.1. And there's also a requirement to produce a project-level landscape and visual impact assessment, which I appreciate we discussed yesterday in terms of having that as a site requirement. I will note that Natural England's support of the growth scenario did reference the landscape and visual impact assessment as a requirement with consultation with the Chilterns Conservation Board and themselves on the detailed design of those proposals. However, we consider that the approach taken by the council, so going back to having the SANG, the sizable buffer on the eastern boundary, so in relation to the setting, and also these landscape considerations within the policy, which are taken directly from this landscape study, we think that overall this is enough to mitigate the impacts for development or guide a decision maker or an applicant to know what to do to mitigate those landscape sensitivities identified.
Okay, so this was all about sensitivity of the landscape. Was there anything else then that the council, in terms of its evidence base, has taken into account in reaching that judgment? And we've heard critique of that. Is there any other landscape evidence that you take into account in terms of reaching that judgment about whether or not this is an appropriate strategy for your local plan?
The short answer to that, sir, is there is nothing that the council has prepared. However, we have naturally had careful regard to what site promoters and those are putting forward in their plans and their ability to, be consistent with the policy requirements as set out within the draft plan.
So you've done this evidence, you've looked at it, it's identified, you've got, moderate high sensitivity to change here, and obviously, for the reasons you set out, you felt comfortable and confident that these, could potentially be overcome at planning application stage. Therefore, that justified its inclusion in the plan. Okay. Right. Let's hear some. Let's start on this side of the room. So mindful, we saw lots of questions over here this morning. So let's start on this side of the room. Mr. Thompson.
Thank you, sir. I wanted to start by, if I may, going back to question 1, because we didn't have the opportunity to open that up to the room, as it were, earlier, and it's the board's position that the Secretary of State's decision is material, obviously, and that the evidence that has been put to the examination in relation to this site hasn't overcome the objections to the proposal, notwithstanding the point made about planning applications and local plan allocations being made in a slightly different policy context. The problem that we're finding is that the summary that the council provided in ED 39 of the justification for the allocation, the council appears to have misled itself over the nature of the Secretary of State's dismissal of the appeal, in that the council says that the impacts can be successfully mitigated, which we do not agree with. We don't think that the Secretary of State's decision just makes that point, but also that the Secretary of State's decision was made solely on Greenbelt grounds, which is patently not the case. And we're struggling to find the justification either in ED 39, which was supposed to clarify the narrative that has led to the allocation of this site, for the allocation, and also what has changed in terms of not just Greenbelt policy but all policy between the Secretary of State's decision and the case being put to you now to allocate this site in the local plan. A lot of discussion has been had on the as I say, the merits of a local plan versus a planning application decision. But the key thing for us is that the case that could have been made on that front by the council in terms of exactly what those differences are has not been made. It's just that section on page 117 of ED 39 just relies on the council's interpretation of the Secretary of State's decision and the fact that they consider that exceptional circumstances exist when very special circumstances didn't, and we need much more consideration of that argument. So I think I would like to rest there on that point, if I may, sir.
Okay, I think we're straying back into things we've already talked about. Ms. Brown.
Thank you. There were a few points I wanted to just pick up really on what was discussed about the landscape evidence that's led us to the allocation. I've got, as you can see, I like post-it notes. Excuse me if I go to the wrong one first. But there was reference there to the earlier wider study that formed part of the Greenbelt Stage 2 work that also included a landscape appraisal and how that looked more widely across the borough, i.e. suggesting that the whole landscape of the borough had been considered. The site itself is considered in a refined sub-area there, quite rightly, but actually that earlier study, I'll just get the text in front of me and find you the references. This is the phase 2 Greenbelt study, CSN 8.1. And I might not have it's quite a long document, but the site's considered in here mostly as part of refined sub-area TR-A3. So, no, that's fair enough. Yeah, CSN 08.1. And that's the stage. Sorry, let me just check if I've got that right myself. That's right. So it's the 2016 Stage 2 Greenbelt Review and Landscape Appraisal. And I will take you through the table that sets out the overall landscape sensitivity judgments, which is table 5.5 specifically. Sorry, table 5.5, and that's page 100 of the PDF document. So that's where we can see the kind of refined subparcels around Tring looked at in terms of their landscape sensitivity. So in 2016, the consideration was that the overall sensitivity of this landscape to residential development is judged to be high by virtue of the relatively intimate, fairly small scale and contained landscape, which has a poor relationship to the settlement. If I then take you through to the kind of conclusions, if you like, of this report, they're summarised in table 5.7, and the reference to this particular site is on PDF page 106. Where you'll see that actually the recommendation of that earlier landscape appraisal was that this site should be excluded from further assessment. So notwithstanding that, the 2020 landscape sensitivity study subsequently picked up this parcel of land and looked at it again. So we've raised numerous concerns with the landscape evidence base on behalf of Tring Town Council. You'll mostly find those set out in a report that's dated 2021 that's appended to the Town Council's consultation response to ED 39. So that's Representative ID 421, where there's a lot more detail in there, but I'll try and take you through the kind of key concerns we have about how the landscape evidence has been prepared and the process that's then evolved through the plan making in terms of interpreting that evidence. So that was the very starting point, that 2016, this wasn't considered to be a landscape that should be considered for development from a landscape perspective. Roll on to 2020 and the landscape sensitivity study. And we find that the landscape is now considered to have a moderate high sensitivity. Now we've flagged various issues with that in terms of the way the assessment has been put together. There are some quite clear errors in that evidence. I'm quite happy to talk you through key points that we have there. But firstly, in terms of looking at landscape value, if I take you to the landscape sensitivity study, which is CSN 10.1, and in that study, TRO3 is parcel 124. And I think the key considerations on that are set out on page 206. In fact, we've just been taken to those by the council, so I won't dwell too long, but I mean, the first line there, you can see the landscape parcel is assessed as having neighbourhood landscape value. Now, if I take you back, again, sorry, lots of flitting around documents, but if I take you back to page 6 of that study, you can see that in terms of landscape value, actually, excuse me, it's page 11 of the PDF, page 6 of the live document. In terms of value, a neighbourhood value is at the bottom of the scale, which clearly can't be correct when you look at this landscape and you look at what's been considered. You know, the council's evidence is placing the value of TRO3 right at the bottom of the pecking order, equivalent to a degraded piece of land, an industrial use, that sort of thing. It's clearly wrong. I can take you through the full range of issues that we found.
I don't think there's much benefit in that. What Mr. Bristow and I want to know, from your point of view, is why you think the plan is unsound.
Yeah.
And why it can't be modified in a way to make it sound. Now, maybe the opposition is that the modification to make it sound is the deletion of the site. Maybe opposition.
That's our position.
That's your position. Good. Right. So what is there, without sort of going through very detailed documents? Let's say we're not in presentation of evidence, we're not in cross-examination. We want to know what is there before us that shows that this site is fundamentally unsound, and that there is nothing that can be done through development plan policies and development requirements that could get to a situation where an acceptable position could be found. So what is there? And we've talked a lot about the methodology, and we've got people's views on methodology and why the methodology is flawed in people's views. In terms of landscape impact of the allocation, what have we got before us that you can point to that says, right, that is a justification why this allocation should not be in your local plan?
Okay. Well, quite frankly, the council haven't put anything forward in terms of showing this is the landscape impact of developing this site compared to other sites. We can see in terms of landscape sensitivity that actually this is one of the most sensitive sites in the district. There isn't actually a very helpful, there's nothing I can point you to specifically in that report. You'll have to go through and do your own kind of adding up of the numbers, if you like. But on my count, there are 34 land parcels looked at in that study. And 27 of those are moderate, high or lower. 21 of them are low or moderate sensitivity. There are clearly lots of sites that have a lower landscape sensitivity, even if you accept that the evidence is sound. My position is that the landscape evidence that has fed into this isn't sound. And there have been various watering down, if you like, of that evidence as it's then been taken through the process of looking at the sustainability appraisal. Mr. Forstick picked up some of the points earlier in relation to greenbelts and landscape in terms of them kind of being rated amber. Amber, one would assume to be the median point, so a moderate sensitivity landscape. That's not what we've got here. We've got something above a moderate high sensitivity. The process is inherently flawed in terms of where we have got to where we have got.
And what I know I'm straying in terms of the agenda, but just for my clarification, is that the same argument you would put to us in terms of TRO2, New Mill, or is there a difference with your argument there compared to here?
We haven't raised a landscape objection to TRO2. In terms of the way it's been considered in a more balanced way in terms of the evidence base, and it picked up most of the sensitivities that we felt were appropriate, and it's been carried through in the same way. It has a lower sensitivity than TRO3. So no, we don't raise the same concerns.
Thank you. Just to come back on a couple of those points there, you asked the direct question as the Town Council's position as to what modification would make this plan sound, and their answer was to remove this allocation. It strikes me that that doesn't help you, because if you remove this allocation, the plan is automatically unsound because it can't then meet its housing needs. So it's not a helpful suggestion to make to you that the plan could be made sound by deletion of this allocation. Just to come back onto the landscape study, my understanding of the evidence put forward by GFRA and the Town Council is that they have no objection to the Dunsley Farm allocation, which has the same landscape sensitivity as TRO3. Neither have they raised concerns about Berkhamsted, which also has high moderate landscape sensitivity, and the other sites that are identified in Berkhamsted, which are alternative sites for housing development, also have high to moderate landscape sensitivity. This is not an argument about whether or not there is harm to the national landscape. All parties accept that there is harm to the national landscape. It's a question of balance as to whether or not that harm is outweighed by the benefits and the need to provide housing in this area. That harm, just to come on to the points that made by the Children's National Landscape and the Town Council, who have conflated the weight to be given to policy, which is great weight, to the actual level of harm that arises. The two are not the same thing. And we have seen from the inspector's decision that the landscape harm in relation to TRO3 is largely mitigated on year 15, and but nevertheless there is harm to which the Secretary of State was then bound to give great weight. We're not saying that that's wrong. We're saying, yes, great weight has to be given to any landscape harm. Our argument is simply that it's substantially outweighed by the benefits of bringing the development forward. Just while I've got the microphone, just one further point on this. We went back to question one, and I know you don't want necessarily to go back to it, but there is one other point to be made about the decision that was being made by the Secretary of State on very special circumstances compared to the decision that you have to make on exceptional circumstances. And that was when the Secretary of State found that very special circumstances weren't made out, they were considering a housing land supply of just over 2 years. Roll forward 2 years, and you're having to consider a situation where there is little over 1 year of housing land supply. So the suggestion that was made by the GRFA that this whole local plan process should pause and go round another loop, which might take another year, is baffling to me. And I do wonder what people who might be watching this, who have children who are trying to get on the housing ladder, who are trying to deliver and want to get an affordable home in this borough, make of any suggestion that we should not be allocating land and meeting the needs of those people. Thank you, sir.
Can I just, I mean, I've heard those points. I think you mentioned in countering the points that we've heard from the Grovefield Residents Association, that there is the same sensitivity in terms, and correct me if I'm wrong, I just want to be clear on this, in terms of TR01 Dunsley Farm. But that's not correct, is it?
It's moderate, and we're moderate high, and there are other sites. As I'm told, there's 14 of the 34 that are in the same category.
Well, that may be your view,
Or
but
higher.
in terms of the landscape sensitivity study, as I have it, there is a difference there. Is that correct? But which, so if you, and then this isn't, I'm not challenging, I mean, obviously your view is that you're both moderate, that's fair enough. But in terms of the evidence we have from the council, the landscape sensitivity study, I think does come out, and correct me if I'm wrong, anyone, comes out for TR01 as moderate and TR03 as moderate high. Is that right? Yeah. Okay. Thank you.
Thompson, I think.
Thank you, sir. Coming back to this point of whether the plan can still be found sound with the deletion of this site, it's our view that, of course, it can be found sound. And I refer to MPPF paragraph 11B, which allows local planning authorities to set a lower housing requirement for their local plan, where policies in the MPPF provide a strong reason for restricting the scale and location of development. And our case here is that there are strong reasons for restricting the scale and location of development in this location. And that...
Yeah, just on that point, because you've preempted my next question, was where do we turn to then? So let's sort of put yourself in our situation. I asked the town council, you know, how can this plan be modified? And they said, delete the site. So in landscape terms then, where do we go in terms of the MPPF to give us any direction as to what we should do in this situation? So let's say we're in a situation, and we'll use this for the basis of this argument, that the council's identified a parcel of land, moderate to high, you know, there's a disagreement there, but, you know, the council has referred to the landscape sensitivities of this site, and there's the evidence out there, there's the Secretary of State's decision, there's the inspector's recommendation, etc., etc. So we're in a situation of moderate to high landscape sensitivity and, like say, harm occurring. Where then do we go in terms of national planning policy to give us direction as local planning inspectors, in your view, as to whether we should find this justified and sound or delete the allegation? So what does the MPPF tell us we should be doing for a site in this location?
Well, this is one of the key issues that we think has been overlooked by the council, but also by the planning inspectors and the Secretary of State. But both the policy and the legal context for national landscapes has changed since 2020, when most of the work that has backed up this local plan was undertaken, including the insertion into the NPPF. I think it's now paragraph 189 of the additional policy on setting, requiring decision makers to, I think the wording is something like sensitively design and locate development in the setting of a national landscape. Nowhere has that new policy been addressed. It's not addressed by the council, it's not addressed by the inspectors in their report, but, and it's not addressed by the Secretary of State. But that's clearly, that was intended to make a difference to the types of decisions that were previously being made in the settings of protected landscapes up to that point. And secondly, there's the change to the statutory duty under Section 85 of the Countryside and Rights of Way Act. And it's interesting the Secretary of State referred to the listed buildings duty in coming to their decision, but not the duty on protected landscapes. And again, neither has the local authority put in any of their evidence that we've seen any consideration of how either that change to the NPPF or the change to legislation has affected their decision making in relation to this proposal. So we're at a stage where the entire evidence that is informing the local plan is out of date because those two factors haven't been taken into account.
I won't go there on the purposes because I've got that evidence and appreciate we get that argument everywhere we go in terms of that. But what I do want to focus on is you're right. What does the NPPF say? I think you're referring to the paragraph, weren't you, where it says development within setting should be sensitively located and designed to avoid or minimise adverse impact on the designated area. Yeah. So turning back to the council then, how do you consider that that requirement has been met?
So in our response to question 6, we've said the proposed SANG within the red line boundary will function as a sizable buffer. So that already sets development back from the edge where its boundaries adjacent to the AONB. We do have the other relevant landscape considerations as well, which we consider with those in policy and the requirement of the project level LVIA, that this would mean we're consistent with paragraph 182 of the framework. And also, I mean, we're going back to matter 2 again, kind of overarching, but I have referred to it again within our response to question 6, saying that this is reflective of the development affecting the setting of the Chilterns AONB at the time position statement prepared by the CCB 2011, which notes that many issues in relation to new development within the setting can be resolved through careful design, appropriate materials, layout, location, mitigation measures from the landscaping. And we consider that the site-specific considerations set those parameters for delivering a scheme consistent with that position, consistent with the framework.
Ms Thompson, your views on that, and I know we can probably guess what you're going to say, but why do you disagree so strongly with that, and why do you think that this isn't a site that could be, or an allocation or a policy that could be modified in any way to ensure, because don't forget, we're not just doing a plan application, we don't have a specific proposal before us. The design, the layout, all those, none of those things are before us. Why do you think this isn't a case that the policy could be amended in such a way that, that you know, the development occurring here could be sensitively located and designed to avoid or minimise adverse impacts?
I think this goes to the examples that have been given to us by the promoters of the site in terms of the applications that they've put in. But this is the only sort of evidence that we have at the moment. And our consideration, there are certain viewpoints within the national landscape. For example, there's one as you come out of Albury Knolls. There's a bench with an interpretation board and a very good view across the site. And when you, it's a key viewpoint. And when you sit at that site, there would still be a significant impact on the view beyond the SANG area, which we do appreciate as Mr. Layden was saying earlier, we do appreciate as providing a buffer should the allocation be accepted. But we don't think it goes far enough in terms of reducing that impact on the setting of the national landscape. And I think much more care needs to be taken in terms of landscape and visual assessment, and also other assessments, because it's not just about visual matters that we need to think about before you can get to a point where you could say that a development of this scale could definitely be mitigated through a development plan proposal. And what we could end up with as a result is a site allocated in a plan and a housing requirement that then puts us straight into a presumption in favour of sustainable development argument later on, and the council being unable to meet its housing targets.
So just throw back on that, because that's a whole new that's a whole new issue. Let's just stick to this. So your position is, and ultimately, I'll sort of spoiler here. It comes down to Mr. Bristow and I need to take this away and actually just go look at the thing and actually study it and study the evidence. You know, it's very difficult, especially a local planning examination, to get into, you know, not get drawn into specifics. Ultimately, what I want to know from you is, we've got an allocation here, we've got a red line, so we know where the allocation is going to go. We know the extent of the land to be retained in the green belt, so we know the sort of size of that buffer. We can see it, it's set out in maps. We know the scale of development, what it's going to include, neighbourhood centre, education, 1,400 homes, etc., etc. So your position, just to be abundantly clear, so I've got this clear in my mind, so when we go look at it, is that that scale of development in this location could not be at a plan application stage, and put in Red Rose application aside, because that's nothing to do with us, could not be at a potential future plan application stage, ever be conceived or designed or brought forward in a way that would meet the requirements of national planning policy. Therefore, the allocation is not justified, and presumably the allocation is not effective either if it can't be delivered.
Yes, that's our position.
Yeah. Okay. Mr. Standard.
Yes, just 2 points of clarification, if I may, sir, through you. I'm actually requesting information here. Reference has been made to a planning application which occupies the same footprint as that which was considered at the appeal. I'm not getting into the application merits or anything like that, but it would be helpful to know from the local authority whether that application is likely to be determined at the 16th of April meeting of the Development Control Development Management Committee, or a later date. So that, through you, if I may, sir, that's a question which I'd appreciate clarification on.
I think that's a worthwhile question, because it's obviously it's something that has been referred to. I don't know. I'm looking here and here for the answer to that. Just
I can answer that. Yes, it is.
Thank you. Sorry, say that. What was the date?
The 16th, Thursday, the 16th of April, Development Management Committee here at Hammond.
Okay.
Thank you. The second question was...
So can we just, is that the council's understanding? Just because
Yes,
I was
it is.
looking this way and seeing some... Yeah,
Yeah.
okay, thank you.
Second question really relates to the subject of unsoundness, which is, I think, your question 8. It's a hypothetical point I want to put here. If, hypothetically, you and your brother inspector found that TRO 3 was unsound, this is a hypothetical point, has the local authority given any consideration in terms of housing need as to where they would locate that need?
I think, to be fair to council, that goes way beyond where we've got to be fair to them. I think really with the landscape evidence in particular, I want to move the debate on, because, as I said, it really there's a lot before us, and with these landscape issues, we've been out already, but we do need to go at the end of this process. We've heard an awful lot about this site. We've heard an awful lot about lots of sites, but this one in particular, and I think that's the crux of the issue. I think Mr. Thompson, to be fair, has sort of hit the nail on the head there. That's the crux of the issue. You know, can this site, it's about the size of it. We've heard lots about size and scale. We've got the council's position is that yes, it can, and we've got this buffer, and we think it can, combined with housing need and all the other things we've heard, we think it's justified, and then we've got very much the opposing view. And I think where it comes to landscape and visual impact and character and appearance and how that feeds into the overall question of soundness, that's ultimately, it's something that we need to just take away and consider and go and look at, essentially.
So, Sarah, if I may, just on the point was made that when you do that exercise, disregard the application that's before you and the detail that's in that, it's fine, and look at what the allocation and the policy, draft policy says as to how you're going to, that might be interpreted in the future. But alongside that, there are other policies in the plan and there are other guidance that the local authority has in place which will impact on how that development site might come forward. Included within that is a very good quality piece of design guidance prepared on behalf of this authority and adopted by them.
What I want to do, because really I want to finish this site before lunch. I think then it's a sort of natural break into the earlier sites in Tring. We may do that, we may not do that. So we've got all day for this session, so please don't think that, if you want to make comments that you've not had opportunity to do so. What I want to do, we'll have a very quick 5-minute comfort break, but I just want to, whilst we've got everybody around the table, just actually look at some of those development requirements. So again, we've heard a lot about why the plan is unsound and why this allocation should be deleted. We've not actually looked at what the policy says yet. And I do want to spend a bit of time whilst I've got people around the table just exploring what that says. And then we'll see how we get to whether we sort of do a sort of mopping up and a wrapping up, or whether we have lunch and come back to it. As I said, we've got all day. I'm not rushing anybody whatsoever. But if that's okay with everybody, we'll have a quick 5-minute break, and then I just want to spend a bit of time actually unpicking what this policy actually says. Mr. Bristow, are you happy with that?
Yeah, and just to flag up one thing that comes through is I'm very happy with that approach. The relationship to some extent will probably naturally blur into, because it is an urban design principle, the relationship with TRO2 will probably naturally come onto that as part of the next session as well. Okay, thank you.
Yeah, we'll just take a quick 5-minute break, and then we'll just sort of unpick some of the actual policy requirements, and then we can come back to any sort of other points that people wish to make. Okay, thank you. Okay, thank you all. We'll resume and continue. What I want to do is, as I said, have a look at some of the development requirements and understand why TRO3 includes the things it does. So we've got all day on Tring, so we're not in a rush. We'll probably then have a lunch break and then come back and have a bit of a mopping up session on TRO3 and really understand the key issues that people want us to take away. Obviously, we're well aware of those, but really focus on what the key soundness issues are. And as I said to Mr. Thompson and others, really focusing on, at the end of the day, for representatives, it's your representations are to why the plan should be changed, and that's the key for us. Why should the plan be changed, and in what way? So we'll have a bit of a mock session after lunch. So TRO3, if I could, I'm not sure if it's Ms. Mitchell or Ms. Aladen. In terms of the mix of uses, there's been lots of discussion around and I've taken representatives to it in ED 39, especially around the benefits of this scheme and what it will deliver. So just talk us through the size, scale, and mix of uses and how they came to be about from the council's perspective.
Thank you. So I have in the submitted local plan, it says 119 hectares. However, I do note within the statement of common ground, is ED 24, there is a suggested slight adjustment to that to reflect a change, a very minor change in the red line boundary of the site. So I just wanted to raise that. It's not a huge difference, but around 120 hectares with land to be retained within the greenbelt for Sang. Sites proposed to be allocated for around 1,400 homes, including specialist provision. It's subject to master planning. We have a neighbourhood centre, including a sports and community hub. We have a 3 form of entry primary school, 6 form of entry secondary school. On-site Sang, as well as associated public open space. And then we've also got a proposed modification from the NHS ICB Statement of Common Ground, which is ED 46, which is to include specific reference to the provision of a medical centre within that neighbourhood centre. And I guess the site requirements, they came to be through very ongoing iterative process, namely what was promoted by Barrett Redrow, but also with engagement with infrastructure providers and other stakeholders. So the Sang requirements came from engagement with Natural England. We had requirements on education from Hertfordshire County Council, similarly for specialist provision. We've had engagement with the Health Authority, and like we say, we've now agreed a position subject to your consideration to include specific reference to that.
In the evidence where you refer to no technical constraints, so we've heard differences of opinion around impact on greenbelt and landscape in particular. Talk us through what you meant by no technical constraints, and then open it up to anybody who may have a difference of opinion on that. And again, how you've considered these things. What we want to know is how you've tested this scale of development and the mix of uses, and how you've reached a point where you're confident that this is a submitted plan that's sound.
Really sorry to do it to you, sir, but it's firstly going back to question 1, which is the consideration of the Secretary of State decision. There were several potential, potential constraints identified and were examined in detail throughout the process of the inquiry. Try and summarise as best as I can, but the Inspector and the Secretary of State agreed that the development would not adversely affect the integrity of the Chilterns Beechwoods, so the provision of sufficient mitigation. Agreed the measures agreed with the local highway authority would be sufficient mitigation. And they also agreed that the site is in a sustainable location. The paragraph references, by the way, are within paragraph 5.5 of the hearing statements, and then it's points A through to G. I won't quote the SOS decision and the inspector's report each time, but that those references are in there. They said that it wouldn't have an unacceptable impact on highway safety, and cumulative highway impact on the network would not be severe. They said it wouldn't have an adverse effect on the risk of flooding or drainage. And then in paragraph 5.6, the inspector confirmed that the appellants provided clear and compelling evidence of their ability to deliver homes on site within 5 years. And then this was agreed by the Secretary of State. And they both gave substantial weight to the provision of market homes, affordable homes, self and custom built plots, extra care housing as such.
So, and just in the council's trajectory then, where have you got this sitting, and are you comfortable and confident again that you've considered matters relating to viability and deliverability, especially around things such as the school provision, sang provision, etc.?
Just let me get back to where I was. So it's question 7 looks at the anticipated delivery. I kind of repeats previous points about the agreement between Secretary of State and Inspector on the ability to deliver homes within 5 years. We've also prepared a statement of common ground with Barrett Redrow, which is ED 24, where we agreed that the earlier planning application did include a detailed phasing plan for the site, a Section 106 agreement for delivery. For the highways and social community infrastructure, envisaged a start on site less than 3 years following the grant of permission. We didn't see or necessitate any changes to that previously agreed phasing program. However, we agree that first occupations would start within 2029 to 2030. So it's still within the first 5 years, but slightly later than the previously agreed phasing program as part of the earlier inquiry. I think just for your benefit in the matter of detail on this and just the chronology, the submitted plan says 2029, 2030. We then agreed a statement of common ground with Barrett Redrow following the submission of the plan, which proposed to roll this forward. However, we've now, within the addendum to that statement of common ground, have reverted back to 2029, 2030.
Now, this is a cruel question of the council. It has been said by some that I've picked up from representations in terms of Mr. Birkinshaw's questions, how the key land use and development requirements have been established, that those are, if I can phrase it this way, to consume the effects of the scheme rather than to provide facilities which are necessary to address acknowledged lacks at Tring in terms of schools in particular. So where would we go? The question, the cruel question is, where would we go to see what of the land use requirements here, particularly in terms of sports community hub, primary schools, secondary schools, and sang to some extent, is related to the scale of the development proposed, 1,400 homes, relative to what are acknowledged lacks in provision in that respect at Tring presently? Is there somewhere we can go to find the distinction between the two?
Thank you, Sarah. I think the first reference I would go to is our consideration of the overarching ED 39 on this. In light, and with reference to that, looking at this site, which I believe I'm right is PDF and normal page number 116, the 2020 justification on this one. Recognizing, I think looking at our justifications, our recommendations as a whole on this. And within that, the second paragraph of that one, we do say the site has the potential to deliver significant new social and community infrastructure to benefit both new and existing communities when compared to alternative sites. And that's a summary conclusion. I appreciate that. These include a new community hub, formal and informal recreational space, a primary, secondary school, a new link road, between Bulburn Road and Station Road, a high-quality, sustainable transport link to the town centre and to the train station. So, notwithstanding what we said in 2024, which some people might criticise as being too concise, I think you have to read our recommendations as a whole, and the fact we didn't really want to copy and paste something we have already said. So with that, I think when you just kind of roll back and we talk about some elements, a sixth form entry secondary school is going to be a benefit to the wider communities that, you know, in terms of what this scheme is expected to deliver in terms of that. So the SANG is at least 27 hectares, and we know in previous discussions and iterations that the site has the potential to deliver more SANG, which again, from a council's perspective, in an area we don't have our own solutions, is an added benefit that will help unlock growth and perhaps serve wider developments in the area. I mentioned also within that justification, the road that links the highways to the north and to the south, Station Road and Bulburn Road, is something that has added value, but also delivering those wider sustainable transport links between the town centre and the train station. You know, good, safe, accessible, and hopefully, good passive surveillance for those links in an area where we know and has been much kind of talked about. There is some, concerns about how people can safely get there in a sustainable manner from the existing town. So this site, does deliver quite a significant amount of wider benefits with regards to those, just owing to the fact that it may be on site, but it will serve wider communities. Ms. Mitchell.
Apologies. It's also just to note that the scale of development proposed at TR03 is what is enabling those benefits to be viably delivered on site.
That's the heart of my question, really, that we don't have a representative, as far as I'm aware, from the county council on this aspect, who's not here today. But in terms of, say, if I were to, my real question is, where would we go to see, say, existing primary school provision in Tring, existing secondary school provision in and around Tring, and to judge, okay, to what extent is the scheme providing for acknowledged lacks versus to what extent is it accommodating those who would be there as a result of it in itself?
Thank you, sir. So I think the hardest and clearest evidence would be the IDP schedule in terms of the detail and then recognition, earlier discussions about how we've engaged with wider communities. That those schedules and those needs and demands and their criticality has been set out quite clearly in that, in terms of what's necessary and what's desirable and other components. A wider point too, I think, if I may, not just with Tring but with other areas, is that the county council has engaged with us at detail and at various stages and in an ongoing process to refine and update and ensure that whatever the plan had at the point it was finalised was the most appropriate solution with regards to infrastructure. So we do have it within the IDP schedules. Clearly, I think the regulation 20 representations would be further evidence of their view, and I think in light of that, I failed to get the specific paragraph, but statement of common ground we have with the county council. There is a point there that, other than the points clearly specified within this, the parties agreed that, infrastructure provision in relation to education and other elements are considered sound. So if you want, I can go back and clarify that, but I believe that's spelled out within our statement.
That's okay, and I can look in the IDP and I can look in the schedules. That's helpful. Thank you.
Yes, Mr. Gardner in the corner, then sort of open up to any other sort of comments or observations that people have got in terms of the sort of the mix of uses and actually get into some of the detail of what's being proposed.
Yeah, my comment, thank you for letting me speak. My comment is about technical constraints and specifically on TR3, but it also applies to all three sites about water scarcity, the scarcity of supply. Now, the detailed application, which was subsequently refused by the Secretary of State, as part of that application, Thames Water, who supply water and deal with sewage in this area, stated there was insufficient water supply for 49 premises in Tring, spare capacity. And that was a concern when you've got 1,400 houses and a cumulative requirement of over 500,000 litres per day. Since then, and bear in mind that's about 3 years ago, there have been 2 major applications in Tring that have been consented. There's a major care home, which is currently being built and virtually about to open, actually. And there's an extension of Penley Manor Hotel, which is just across the road from TR3. So if there was only spare capacity for 49 dwellings 3 years ago, that's can only have got worse now. Now, I know obviously there's quite an element of developers' risk on that. They'll ask Thames Water for an update as part of the latest application. But I can say that there's no way Thames Water, their advice hasn't changed, and there's no way they can give any firm indication on the water supply improvements at Tring. It links into a much bigger scheme that goes through additional water to Aylesbury Vale, and that's all linked back into HS2 and tunnelling under HS2, and HS2 will give no advice at all on when they would grant that permission. So that's a large risk item on technical constraints, and it doesn't just apply to TR3, it applies to all 3 sites. That's my comment.
Any other comments on sort of uses, mix of uses, what's being proposed? As I said, we sort of skipped over the question on sort of size and scale, just because we've talked about it quite a bit already. Was there anything else that anybody wanted to add on size and scale that I haven't already said in any of the hearings thus far? No, Mr. Thompson, you were looking like you might want to, but...
No, I've said all I need to say on scale, I think so.
Okay. Mr. Bristol, anything else on those specific points around the development requirements, the mix of uses, what's being proposed?
No, I did want to touch on the relationship with TRO2 at some point, but that's not for now, probably. Yeah.
Okay, as I said, they were the only questions that we wanted to go through. Obviously, it is an opportunity, the hearing, to put forward your points. Is there anything else on TRO3 that people wish to raise that we haven't discussed, or anything you think, I wish I'd said that? Ms. Brown, just thinking, yeah.
So it was really just a case of putting into context, if you like, the landscape that you're going to be looking at when you go out on site. That, yes, the evidence base is showing moderate high sensitivity, but it's quite a unique landscape as well that we're looking at around Tring. The town itself is positioned in a natural gap between the Chiltern Hills. So the countryside around Tring, or certainly to the south and east of Tring, lies in the foothills to the High Scarp. You don't have that situation in other parts of the borough. The High Scarp being one of the most recognisable chalk escarpments in the country. That arcs around the town and creates quite a dramatic backdrop to the town and to the sites that we're looking at and the surrounding landscape. And it allows panoramic views that you will no doubt go out and see. But as well as that, so those panoramic views are one of the special qualities of the national landscape, as Dr. Thompson had alluded to. As well as that, there are views towards the A1B, towards the national landscape, sorry, and the Scarp, and those were specifically picked up by the Secretary of State and the Inspector. I can give you the reference to those if you need it. It's in the Secretary of State decision, which is SSA 06.1. And I'll take you to the Secretary of State reference, which is paragraph 30. Where he's discussing views of the A1B from the public rights of way. So it isn't just the panoramic views from the Scarp looking down on the site. In the particular circumstances of TRO3, is the views looking back towards the national landscape, because of course this site's completely, well, it's encircled by the national landscape on 3 sides. I just really wanted to make sure that was fresh in your minds.
Thanks. Thank you.
As I said, we've actually got all day scheduled for this. So as I said, you want to look at the relationship with TRO2. Happy to, do you want to do that now or after lunch?
Well, it's really just a very brief question, and it's more about delivery and the relationship of TRO2, which we're going to come on to after lunch, to TRO3. And this goes at Mr. Birkinshaw's direction to some of the principles. So if we are under urban design principle 3 of TRO3, the allocations of TRO3 and TRO2 should be planned together through closely aligned master plans, taking an integrated approach to the joint site area. Now, I'm moving into effectiveness. I'm not commenting on anything else that we've discussed. And we have TRO2, the requirement under Urban Design Principle 3, that they should be planned together through closely aligned master plans, taking an integrated approach. They have different delivery schedules. So we've heard TRO3 east of Tring 2029-30, TRO2 2027-2028. 2 questions. Should those be aligned? And the slightly harder question is that if, say, our reasoning was, and this is entirely hypothetical, to take us that TRO3 was not justified, would that automatically therefore lead to TRO2 not being justified?
Thank you. I'll take first question. I think our intention was to ensure that they were aligned. So having so we've got closely aligned master plans, taking an integrated approach. We believe that would provide sufficient flexibility. Obviously, I welcome feedback in terms of plan together. When you isolate it in that way, I can completely understand your point regarding effectiveness. They do have different delivery schedules. I think the intention in drafting was to say they should have closely aligned master plans, ensuring that there's permeability between the sites. Now, this is quite niche, I'm afraid, but in policy TRO2, there's a similar, I think it's the same design point, which says that we should ensure high quality GI and sustainable transport linkages provided with the adjacent allocation. And that's the same point within point 4 of point 5, very similar, TRO3, just to say within the statement of common ground with Catesby Estates, we have suggested, which is TRO2 site promoter, we've suggested a minor modification to point 4 of TRO2, which essentially deletes the last half of the sentence, essentially reflecting the fact that the community hub, local centre, primary and secondary schools are within TRO3. So they can't ensure that the sustainable transport linkages are provided to those locations specifically, because then they're not within their area, but we want to ensure that the sites are still closely planned.
Which preempt, don't apologise for being niche. I mean, we are planning inspectors. That's what we do. But that brings me on to another point, which is effectively, is TRO2 reliant on TRO3, the infrastructure? So I'm just raising this because, well, various bits and pieces in terms of infrastructure proposed at TRO3, there's a connection with TRO2. So part of our consideration is whether sites are justified. If we are going down the route, hypothetical, that TRO3 is not, well, what happens to TRO2, really?
So the TRO2 could be developed without TRO3. It's got its own access points. It's within its own ownership.
Yeah.
In terms of infrastructure capacity, I think we'd have to do some more detailed testing in terms of primary school capacity, but I'm looking at Ronan here on that because he might have the detail. But I believe that this could result in issues should TR03 be deleted in terms of, say, capacity of primary school, secondary schools, in particular, medical facilities, all these things being provided on TR03. They aren't suggested to be provided on TR02. There might have to be revisions to the capacity of TR02 potentially, and that's not something that we're supportive of.
So I can help on that. The implication, if TR03 doesn't come forward, adjustments would have to be made to TR02 and also to Dunsley Farm, which is the other potential site for a primary school to be located. TR02 is reliant on TR03 to deliver its SANG as well. So there are close links between the two in terms of delivery. There is no prejudice to TR02 coming forward through TR03, either in timing or physically, and that's been demonstrated through the proposal that was discussed at the inquiry, where there is a potential guaranteed links through for occupiers of TR02 to come through the TR03 site and use the community facilities. The Redrow Barrett group now, as the largest house builder, is intending to develop this site out using all three of their divisions, starting both at Bulburn Road and Station Road. So there will be development starting close to TR02 within the first phase.
So just on that, is there anything, I guess, question of the councillor in the first instance, is there a requirement for the two sites to be linked in their delivery in any way? Or is it more about good design and connectivity, etc.?
No requirement in terms of requiring to be delivered together. I believe in 2020 we softened requirements on that to provide sufficient flexibility, but we do think that the design requirements are about, like we say, ensuring connectivity to facilities, etc., sustainable development, connections to the station.
This obviously comes into the issues on TR02 later on, but in our hearing statement at paragraph 65, we address this. And if you read all of the documents, all of the historic evidence documents for New Mill, in terms of all of the social infrastructure and the highways and the sustainability and the schools, all of it is dependent on TR03. And there hasn't been any self-contained, at least as we understand it, in all the material we've read, we can't see any self-contained standalone justification for TR02 without TR03.
There's, just to be absolutely clear, and this is maybe falls ironically between Mr. Forsdick and Professor May, but there's no comparable connection, or is there, with TR01 in terms of SANG infrastructure? I know it's a different thing. I'm very well aware of that, but there's no relationship there. You mentioned SANG in terms of the connection TR03, TR02. It seems that that's agreed, that there is a relationship between the two and a reliance to some extent between those, but that doesn't extend to TR01.
Not directly, although there is potential within TR03 to provide SANG, which would release TR01. We still is going to have to provide it somewhere.
That was our understanding.
It's just really helpful in terms of clarifying effectively what we're dealing with. Ms. Layden.
I think just on a point of clarity, just so we're clear going into the afternoon session, the plan, I'm thinking about the three sites here and trying to get the numbers correct. TR03 is delivering SANG that will serve its needs and potential access. TR01, which is the county council land at Dunsley Farm,